Anyway, I just thought I'd tell you who we were. For those who don't know us, I am a barrister. I've been specialising in clinical negligence for around 25 years and have been spending the last week or so wondering, after publication of the report that we're going to discuss today, how I'm going to meet my future mortgage payments. And I'm delighted to say that we also have Lord Edward Faulks QC, also specialising in clinical negligence, possibly even for a little longer than I have been. And I can say this about him, he wouldn't dream of saying it about himself. He is one of the, if not the, preeminent tort silks of his generation, appearing in numerous Supreme Court cases, and of course in the Court of Appeal on many, many occasions. And also, helpfully for our purposes today, a Minister of State for Justice in the House of Lords from 2013 to 2016. So we will be delighted not only to have his views of the proposed reforms that are set out in the report we're going to discuss, but also have his view on the political implications of the report, whether or not it's going to gather dust on a shelf or whether any of these proposals might really happen. And it should be noted that I'm using political in the sense of the machinery of government and not party political because, Ed, I think you're now, at least according to your Wikipedia page, unaffiliated to any party.
That's correct.
So I'm going to give you a quick tour of the report in question, setting out its key conclusions and its proposals for change, and then Ed will give you his views on the report generally, I hope, and talk about the prospect of any of the proposed reforms actually reaching the statute books. So let's get started. What are we talking about? We're talking about the House of Commons Health and Social Care Committee, which is chaired by Jeremy Hunt MP. I think there are a total of 11 MPs on this committee, and they produced a report entitled NHS Litigation Reform. I think reading it, it might actually have been more aptly titled NHS Litigation Abolition. It was authorised to be printed on the 20th of April, not actually published. I think it was published and first saw the light of day last week, and I probably should have known about it in advance, but I didn't, and I first heard about it when I heard it being discussed on the Today programme last Wednesday morning, I think. This committee produced a report having heard live evidence from, I think, a total of 18 witnesses, 3 of whom were essentially participants in the clinical negligence system from the patient-claimant perspective. They heard evidence over 3 days back in November and also February of this year. So this report has actually been concluded quite quickly, it seems to me, after conclusion of the live evidence. They had written submissions from nearly 70 sources, including the list that you can see that I've set out in the slide. The solicitors on both sides, I think, might be described as the people that one would expect to see, they are listed in the appendix to the report if anyone wishes to see exactly who they were. Well, what I'm going to do is look at the key conclusions of the report and then examine the key proposals for reform. And then as for the status of the report, and he'll give us, I hope, his overview of it, and then deal with the recommendations, I'm going to hand over to Ed. And when I say the recommendations, I mean whether or not they will actually ever be implemented and what the chances of that are. The chances of that is. So, the key conclusions, really the foundation of the proposals for change, is this phrase, which is repeated on a number of occasions in the report: the system for compensating injured patients in England is not fit for purpose. I've taken it from paragraph 84, the page references and square numbers are paragraphs in the report. And that phrase appears on a number of occasions, and it is echoed by something that is quoted in the report from Sir Ian Kennedy, who chaired the Bristol Royal Infirmary Inquiry and is now a professor of health law, I think it is, at University College London, that our system for compensating injured patients is outdated, arbitrary, and scandalously expensive. Just really anecdotally, on reading through the report, the committee really again and again relies quite heavily on the lived experience, the 3 witnesses, the live witnesses I mentioned, who've actually been through the process of claiming damages for clinical negligence, and Sir Robert Francis, who chaired the Staffordshire inquiry, and also for a body which I'm afraid I didn't know about before reading this report, the Centre for Socio-Legal Studies, based in the University of Oxford. And really there are three central conclusions when they examine the current system for claiming damages for clinical negligence. One is cost. It's too expensive. Two is delay. It takes too long. And three, it does not promote learning or patient safety, by which they mean that essentially win or lose, patients, injured patients are unhappy, and that the current system does not make for better doctors. So having drawn those conclusions, let me just tell you I'll give you some detail about what they're based on. Cost, unsurprisingly, I think you'll agree, is the main driver for the proposed changes. And I thought you'd be interested to see some of the headlines, because I think the headline cost information, which is included in paragraphs 41 to 43, gives you an idea of why it is that ultimately, really, this report comes up with the conclusion that something has to change. 2011, 900 million pounds was paid in compensation, and that had increased 10 years later to 2.17 billion. And it is thought by, I think, the Treasury that this is set to double by 2031. The total liabilities as at March 2007 for the NHS, and that's all claims, current claims, predicted claims and costs, 9 billion, now 82.4 billion. I think that figure comes from 2020. Projected costs by the end of the decade, 155 billion, with annual cash payments of 4.3 billion. Legal costs increased from 98 million in 2006 to 496 million in 2016. And one headline fact that was relied on that I haven't given you, which I'll give you now, is that costs exceed damages in 74% of cases with a value of below £50,000. Treasury figures in 2020, the provision for clinical negligence claims is £3,600 per household in England and £700 10 years ago, which is not only a significant increase, but seems to me to be a pretty extraordinary figure. One thing you might thought this report would try to get to grips with is why this has happened. But really all the report does is to shrug and say, well, we're not really sure. The government made submissions that one factor was the increasing cost of social care. Another factor might be the increase in life expectancy, although we know that that's flattened out and might even be tailing off now. Another suggestion, I can't remember who made it, was that judges have lowered the bar successively over the years for establishing negligence. But really there isn't any clarity on why this is, but as it were, the unspoken hint in the report is that it's very substantially to do with claimant legal firms only taking the highest value cases and the cases on which they can therefore make the most money. That isn't, I don't think, said expressly, but certainly there's a clear hint in some of the conclusions that that is what is going on. As for delay, the report sets out that in 2017, the average time period from a birth-related injury settlement was 11.5 years. That again comes from this body, the Centre for Socio-Legal Studies in Oxford. I don't see in the report any analysis of that 11.5 years, whether it's been statistically broken down so that you can actually look at when the claim was first intimated, because you'll see that it's from the injury to the date of settlement. So if a family doesn't actually go to lawyers until a child is aged 10, then that would not mean that 11.5 years was particularly significant. But one can see that the impression given by the report and the conclusion that has been reached is that on average, families with severely injured family members have to soldier on through around 11.5 years to get anywhere and to get the compensation that they need and deserve. The report did note that the relatively recent NHS scheme, the early notification scheme, has had some success in providing much earlier results for families. But I have to say that my experience of the ENS is that it is often relatively straightforward to identify whether or not there has been something that could be described in our traditional terms as a breach of duty, but often impossible to decide whether or not that breach of duty has caused any or any long-term damage. And that's going to be quite an important factor to think about when we look at the proposals for changing the way in which we deal with clinical negligence in this country. As for learning and patient safety, the involvement of lawyers and the screening process prevents data sharing. What I mean by that is that Irwin Mitchell, I think, made a submission for the committee that, in fact, the claimant solicitors spend a lot of time screening cases. So they actually see a very large percentage of cases that never make it to the NHS's desk because they've been screened out. But what the committee thought was, well, if that's right, why are the costs going up? That doesn't really seem to us to make sense. They also thought that the screening process prevents data sharing. So in other words, individual firms of solicitors looking at cases and saying yes or no, if they say no, then no one learns anything about the reasons behind it or whether or not there are learning points for future patient safety. Trusts, it was said, do not share learning, but no real explanation for that is given. They also noted in passing that litigation may perhaps impede the development of clinical practice, and they quoted an example that had been given to them by Hempson's. I wondered if I could imagine who that might have been who'd given them this anecdotal information, but they said Hempson solicitors noted the implications of a clinical negligence case in the 1950s that had put back the cause of spinal and epidural anesthesia in this country by 40 years. And then they also noted that the threat of litigation undermines confidence in behaviour of health professionals. And none of that, they thought, was conducive to, as they described it, learning and patient safety. So with that as the background and the conclusions that were reached by the committee, they looked at what they might do in terms of proposals for change. And all through the report, there is a clear reliance on other international schemes, and they drew heavily on the practical experience of schemes in New Zealand, Sweden, and actually across Scandinavia, Japan, and some US states, including Virginia and Florida. And they have persuaded themselves on the basis of cost per capita, percentage cost of GDP, and percentage cost of total health spend, that administrative schemes are across the board cheaper than our current clinical negligence scheme for claiming damages. They recognised, and I think they were right to recognise, that there may be some difficulty in interpretation of these figures because, for example, compensation levels under the scheme in Sweden might well be a lot less than compensation levels that we would have in this country for claims for clinical negligence, and that might skew the overall figures. But nonetheless, they were convinced that administrative schemes would reduce overall cost, even though claims might increase. I have to say that my reaction to that is that although that was a conclusion in the report, I wasn't absolutely convinced that that could necessarily be said with the confidence with which it is expressed. So the fundamental proposal for change is that we should have an independent administrative body, like an ombudsman, to investigate harmful medical events. It should be inquisitorial. It should ask the central question, was the harm avoidable? And it should focus on the system, by which I mean systemic practice. Did the system fail? Did the system fall down? That's really the most important thing. They think not only from a learning perspective, but also, as we'll see, from a compensation perspective. And that, I think, causes considerable problems. The committee has advised that initially the independent administrative body investigating and awarding compensation should operate in respect to birth injury cases only. But the clear intention would be that this would be rolled out for all clinical negligence claims in due course. So how would the new body apply principles in order to establish whether or not somebody is entitled to compensation? So if I haven't explained it properly already, it is suggested that this body would effectively not only investigate, but also determine whether or not people are eligible for compensation and award compensation. The wording in the report is that the body would examine whether correct procedures were not followed and whether the system failed to perform. And it's stressed on numerous occasions that this is not the Bolam negligence test. There's a recognition in the report that the threshold for establishing a right to compensation might be difficult to define. And this was the moment when I was reading the report that I thought this has to be an underestimate of the difficulties that would be faced by an administrative body. And I just started rolling through my mind some of the Supreme Court cases that we've had perhaps in the last 20 years that have dealt with important aspects of causation and are all clinical negligence cases. For example, Hodson, Gregg and Scott, Chester and Afshar, and only last year, Khan and Meadows. There are many others that could be mentioned. And I thought, is it really being suggested that in cases where one identifies that correct procedures were not followed and that the system failed to perform, one does not also have to ask oneself the question, did that actually lead to avoidable harm? And if you go down that route, and you're thinking about whether or not it led to avoidable harm, are you not applying what we would all regard as clinical negligence lawyers as a standard causation test? And if you're doing that, why is an administrative body going to be any better placed to deal with it than the common law and the system that we already have? And why is it going to be cheaper and easier for an administrative body to do that? And in the course of the report, they do note that, I think his name is Michael Mercier, who is at least partly responsible for the administration of the no-fault compensation scheme in New Zealand, that causation in those cases had caused real difficulties. In New Zealand, my understanding is that if you have a result from a medical procedure, which is something that would not ordinarily be expected to occur, that you are then eligible for compensation. And that relatively simply expressed test has caused real problems and complication. As for the level of damages, well, the recommendation is that the administrative body would award damages which would essentially be tort damages, subject to the exceptions that we'll look at in a moment. But that immediately struck me as, again, a potentially expensive and difficult task for any number of reasons for the administrative body that is proposed. They're going to have to get down and dirty with quantification. They're going to have to look at presumably the types of expert evidence that we all have to get anyway, so that expense is going to be incurred, and who is going to pay for it? And for some, well, the reason I think that they rejected the idea of a tariff provision was because they, at this point in the report, at any rate, were swayed by the submissions that were made by those, if I can put it broadly, who are on the claimant side. Swayed by Peter Walsh of AVMAR and Bar Council and other advocates for the principle of full compensation. And that, I think, is the reason why the committee ultimately decided that this administrative body should really be awarding full tort compensation. Subject to these exceptions, they would abolish the Peters principle, by which I mean claimants simply being able to elect private care provision rather than state care provision. And they would say that state care provision should not form a part of the damages, save to the extent that it needs to be topped up privately. My immediate response to that was, well, that is going to be a complicated exercise, working out by how much and to what extent and why state care needs to be topped up, and if so, by how much. The committee recommends the repeal of Section 2.4 of the Law Reform Personal Injuries Act 1948. In other words, that the availability of NHS provision for care is not to be taken into account when considering the reasonableness of any future expenses, so effectively eliminating the duty to mitigate loss. And the other thing they would do is they would standardise loss of earnings claims at the average national wage for all claimants under the age of 18. Now, I don't know whether it's all claimants under the age of 18, but the standardisation for loss of earnings at the average national wage is, I think, drawn from the Swedish scheme. The difficulty with that seems to me to be, well, I think there are a number of problems with it. This was, I think, the thing that first attracted the media, because when I was listening on the Today programme last week, that's really what I heard. It's this idea that the daughter, the severely injured daughter of a cleaner should get less for loss of earnings than the daughter of a banker. That was not only the highlight in the report that was reported on the BBC, but anyone who read Polly Toynbee's article in The Guardian yesterday, about, which is, I think is entitled, "When the NHS Spends Billions on PI Cases, It's the Public That Loses." That again was formed a major part of her analysis and argument, and it suggested this is obviously so totally unfair that loss of earnings should be standardised. But my reaction to that is that it's not a committee seems to have understood that it's almost a sort of automatic that the child of a high-earning parent will have a loss of earnings calculated by the earnings of that high-earning parent. But I think the test is slightly more subtle in that. And then I asked myself about, really, is it really intended that this should apply to all claimants in clinical negligence cases under the age of 18? And I thought about the professional footballer on the books of Manchester City with an age-level England performance background who's injured in a road traffic accident and goes to hospital and they miss a leg fracture that actually completely ruins that 15-year-old's professional football career. Is it really being suggested that that person should have a standardised loss of earnings claim? Perhaps they didn't think about it, I don't know. And then I thought about accommodation claims, and that as a result of accidents and geography and lifestyle and so on, there can be very different calculations of claims for accommodation depending on property available in the relevant area. And then I thought about private healthcare. And I wondered how this would play in the media if you had wealthy hedge fund managers who have private healthcare, and mother gives birth in a private hospital and the child is very severely injured, and they have damages calculated on the contractual basis, which are effectively the same as on the tortious basis now. And so those privately paying patients would have claims for damages that are much higher than those for NHS patients. And I wondered how that would play out, and whether or not that too could be regarded as potentially unfair. The effect on litigation, it's proposed that the right to litigate in the courts would be preserved, but claimants should go through the new system before being granted access to the courts, and this would include compulsory alternative dispute resolution if the claim was not dealt with satisfactorily by the new body. So effectively there would be two hoops that you'd have to go through before being able to bring a claim in the courts. On delay, the committee thinks that the new system will establish liability and compensation entitlement within weeks rather than years. And I have to say that I think that is supremely over-optimistic. I can see, and the early notification scheme has, I think, shown this, that you can sometimes, not invariably, sometimes identify cases where there is a clear liability. But even though there's a clear liability, you've no idea at an early stage, and certainly not within weeks, what that liability is. And in both the ENS cases that I've seen and many other cases that I've seen, one has been told by experts that you can have babies with terrible pH cord gases who need resuscitation, who may even have encephalopathy, and for all the world look as though they're going to have really serious brain injuries, and yet 6 months, a year, 2 years afterwards apparently have done really well, and there's no discernible injury there. So how it's thought that the new system, as they think, will establish liability and compensation entitlement within weeks rather than years, I really find that very difficult to understand. The committee suggests regular reviews. So after you have your initial investigation and you establish that you're entitled to compensation, you move away from once and for all settlements, and that inevitably means that there's going to have to be a regular review of what is required in terms of compensation. Although the committee is advocating tort compensation, I don't see how the regular review really fits in with that at all, and I don't understand how it is thought that that would diminish both time and expense, and also stress, if families are going to have to keep going back to have a case reviewed and to fight for the compensation that they think they deserve at that stage, which they weren't given at the previous annual review or whatever it is. As for the promotion of learning, it suggested there should be parallel investigations. There's some mention of the Healthcare Safety Investigation Branch, HSIB, which is, I understand, to be replaced now by something called a Special Health Authority, who will take over what HSIB was doing, which was effectively providing investigations without making comments on liability or breach of duty. But my own experience of HSIB investigations, which I think are looked on favourably by the committee, is not universally favourable. And I recently had a case in which HSIB had made swingeing criticisms of a trust for failing to give information to a mother. In fact, I was acting for the claimant, for failing to give information to a mother about the risks and benefits of vaginal birth after caesarean, VBAC. And looking at the HSIB report, it seemed to us, representing the claimant, that these swindling criticisms were obviously favourable and helpful to us. But when we looked at the documents, we found a clear written document in which all the information about VBAC was contained, and which simply had been missed in the HSIB investigation. And the expert in my case said, HSIB investigations are not worth the paper they're printed on. So I would have little confidence that the current level and state of investigation is something that can reliably replace the sort of in-depth and detailed analysis that currently takes place in clinical negligence claims. The committee suggested that staff should be trained in just culture practices for additional support, and don't define what that is, and I'm afraid I am unable to help. The committee made various challenges to the government, asking the government to explain why the NHS can only pay damages where it has conceded that negligence occurred, which seems to me just to be a misunderstanding of the position, because of course we all know of cases in which the NHS does settle even when liability is not admitted, either on a percentage basis or an economic financial basis. So I think that simply may have been a misunderstanding. They do deal with fixed costs as are proposed for claims of £25,000 or less, and invite the government to explain how this will not inhibit access to justice. And then they say that quacks should be abolished if claimants refuse to accept the compensation offered by the administrative body, and then they fail to beat such an offer or fail to establish liability in court. Then the usual consequences should apply. So that is a whistle-stop tour through the report and its various conclusions. I've made one or two comments on the way that might suggest that I'm not convinced that every aspect of the proposals that are made have been thought through sufficiently. I don't know, but I thought what I'd do now is hand over to you, Ed, to tell us, if you have any, what your sort of overview of the report is, and then perhaps give us a little bit of information about what its status is and the chances of its recommendations ever being implemented. So over to you, Ed.
Thanks, Ed. Ed gave me one piece of advice. He said, please don't make that joke about two Eds being better than one. So I won't do that. What do I think of the report? I think it has to be seen in terms of what it is, which is a report from a committee. A report from a committee has some general value in terms of a contribution to the debate, but it's not usually the precursor to legislation. If there's going to be some substantial change in the law, it's usually a green paper, a white paper, a draft bill with pre-legislative scrutiny. In other words, this is very much a sort of shot across the bows, it seems to me. It's the case that these observations about the unsatisfactory nature of clinical negligence litigation are nothing new. Various government bodies have commented on this. Different governments have thought that they could do something about it and yet haven't really. They all say certain things, that it's too expensive, that cases take too long, too much money is spent on lawyers. That's always a popular thing to say in electoral terms, and that sufficient lessons are not learned. And these are the points that are made in this report. So there's nothing new there. The sums of money are, however, eye-watering. I think we'd all agree on that. But of course, one has to bear in mind the size of the NHS and the number of interactions between patients, healthcare professionals, and the range of things that can conceivably go wrong. But what are these changes? Are they a good idea or a bad idea? I have to say I'm not very enthusiastic about them. The setting up of an administrative body, which seems to me, what I've seen, almost entirely to duplicate what judges do anyway. And I wonder if there was really sufficient note taken of what actually happens in big clinical negligence cases, with which I'm sure most of you are familiar, where there are negotiations, roundtable settlements, experienced experts. The lawyers actually who do these cases do know what they're doing. And whether you call it ADR or whatever, there are ways of sorting these things out. I think creating an administrative body, I just don't see how that's going to help. Of course, it's also rather contrary to the government's dislike of the creation of quangos, and there is some suggestion that in fact the government is going to start abolishing quangos. So in my view, there are going to be at least 2 quangos set up by this particular recommendation. So that's not going to make it very attractive. In terms of what change could be made, there has been talk over the years of doing something about Bolan, whether you can change it. And I do sometimes think that that direction that Mr. Justice McNair gave to the jury all those years ago is not always truly reflected in the way that judges look at cases. A suboptimal outcome is not, of course, negligence. But I think it's going to be very difficult to find a different formulation, frankly. So why are these claims continuing to escalate? I don't think they really came up with an answer, but it seems to me that the answer probably is significantly affected by the fact that there are lawyers who are much better at finding these cases, but also the cost of care in particular seems easily to be the largest item. We're all familiar with the schedules that follow a substantial claim, and the counter schedules where even if there's a disagreement between care experts for a lifetime's care, the sums are very significant indeed. Will this package of recommendations be attractive to this government or any government? I don't think it will. Why? Because the real question will be, well, it's going to have some initial popularity. We're getting a grip on this. But the Treasury comes into all these things. How much money is going to be actually saved by this scheme? It's interesting that the suggestion is, in fact, there's going to be an increase in the number of cases that are going to be considered by this administrative body. So the Secretary of State for Health will have to say, well, actually, to I think his colleagues in the cabinet, this is going to cost more than the existing system to start with. So in other words, any benefits in terms of reducing costs are going to be some way off. When you have an election that's taking place in just over 2 years' time, that's not very attractive. And the question is, will it actually save money? Now here, the only real recommendation I think that has some potential meat is in relation to the costs, the repeal of Section 2.4 of the 1948 Act and a revision of Peters. And I think that could conceivably form the basis of a damages act, a separate act on damages in personal injury and medical negligence claims. There are arguments, and I'm not saying which is right or wrong, but there are arguments that if you have a system, a state-provided system of care free at the point of delivery, it's rather odd that you should be able to elect entirely a private scheme with enormous cost implications. And also there is the randomness of those who are unfortunate enough, for example, to have a brain damaged baby through no fault of anybody's, and those who can attribute it to a fault on the part of the obstetrician, midwife, or whatever it might be. But that would result in some deduction, but of course it would be very unpopular because there's a very well established principle of full compensation. And I can see that politically that would be a mixed message. We're saving costs, but we're going to deny deserving claimants their full compensation. So I'm not sure that's going to be terribly attractive. But the question of reducing costs also won't come in straight away. Of course, Jeremy Hunt, who chairs this committee, was actually Secretary of State for Health for some considerable time. He did, in fact, make some initial noises about doing something about clinical negligence. I even went to a meeting, I remember, but I was removed from that on the basis I seemed to know too much about the subject. Of course, that's always very unpopular. So he didn't do anything about it then. I suppose it's possible in a political climate where the current Prime Minister may conceivably not be Prime Minister at the end of the year, and it's possible that Jeremy Hunt might be the Prime Minister, that he might want to own some policy. I suppose that's possible. But I think the points I make about how long it's going to take to actually see a benefit are also relevant, even if he is Prime Minister, because it's going to take a long time to get this legislation through Parliament, if there is legislation, and a long time for it to show any real benefit. So I rather doubt that this is going to have much effect. It may make a contribution to the debate, but this sort of legislation seems to be very much the sort of legislation that you have in the first session of a government, when you've got time to consider it, you've got time to see the benefits, rather than a government which has got a huge legislative programme. It's got a lot of economic crimes bill coming up, online safety bill, which is going to be a major piece of legislation, not to mention various further immigration, criminal justice bills and so forth. So it's a crowded programme. On Tuesday, the Queen's speech takes place. There are going to be a lot of bills in there. So I think that it's probably something that will contribute to the debate, which will alarm people, which will infuriate people, but probably won't amount to much. But I could, of course, be wrong.
Ed, that's fantastic. Thank you very much indeed for that. That's extremely interesting and helpful. Now, the one thing that I didn't do, but which I promised I would do, so I'm going to do it now, even though it's a little later than it should have been, is to say that if anyone has any questions, could you use the Q&A tab? And then I will be able to have a look at those questions and we'll be able to do our best to answer them. So if you do have any questions, please put them in the Q&A tab on your screen. But in the meantime, we have had a number of questions that were submitted before we began. So I thought we might just have a look at those, Ed, and see how we can best deal with them. So the first one is, what do we think would be the likely appetite for such reforms, given the ongoing consultation on fixed costs in clinical negligence cases? And I would say that the question of fixed costs is addressed in the report, and they mentioned the original Jackson proposal, which was, I think, that there could be or should be fixed costs in claims up to 250,000. But that, I think, has been pretty much dismissed. And of course, the government is now thinking about fixed recoverable costs in clinical negligence cases of £25,000 or under. And all the report really says about that is, as I've already mentioned, that the government should tell us why it is, or reassure us that that is not going to deny access to justice. I can read out exactly what they say. We are concerned that the government's proposal to introduce fixed recoverable costs in clinical negligence cases below 25,000 may compromise access to justice for the poorest claimants. The government is right to try and rein in excessive legal costs, but until the administrative scheme we are recommending is introduced in full, it must ensure that all injured patients retain access to adequate legal representation. So I think the committee's view is that the government should implement its administrative body proposal, and once it does, the question of fixed recoverable costs just goes out of the window. My feeling overall is that, having heard what you have to say about it, Ed, I'm not sure that the government will necessarily do anything in response to the challenge that's been thrown at it by this committee, and will simply carry on with its plans for fixed recoverable costs under 25,000.
I think that's probably right. One thing I think I just picked up on the chat, I think it was from Afsal actually, an old friend of ours. He asked about what about the effect on routine personal injury claims. Of course, it's going to be rather odd if you have a special regime for clinical negligence claims with caps on damages and so forth. It would have to cover ordinary personal injury claims where all the same questions of quantum come in. So that's another factor, I think, which will complicate it and which probably militate against there being such wide-scale tort reform. There hasn't been much tort reform. It tends to be little small, bite-sized changes rather than anything radical.
Yeah. The next question we had in advance, do you think all parts of the recommendations will be enacted? If not, which parts? Well, Ed, I think you've probably given us the best steer that we could get on that. You thought, I think, that the Section 2.4 of the 1948 Act and the Peters principle might well be things that could be looked at more closely. But of course, you wondered how that would play. You know, if compensation is being reduced.
I think that, frankly, it would be very unpopular, but if you really want to do something about the costs of medical negligence cases, clinical negligence cases, you have a tariff, like they do with criminal injuries compensation. I think that would cause a great outcry, but it would make a difference. And they do it in other countries, they do it in other states in America, a tariff or a cap, or something where you just know what the total amount you can get will be. It's open-ended at the moment. I think if I was a Secretary of State trying to sell it to my cabinet members, I would say, look, I want to produce a bill which is going to limit the amount of damages that you can recover in tort. Of course, particularly clinical negligence, but all tort, using some of the principles that they've identified. That's what I'd try and do. I still don't think it's likely to happen because it would cause quite an outcry. But it is the only way you're really going to make, in my view, a significant difference to the bill.
Do you think there's anything in my concern about, well, not concern, but my imagining how it would play out if you then compared NHS patients to private patients getting whacking great sums of money in compensation, but NHS patients having to make do with a tariff?
No, I think it's absolutely, it's very, very unattractive, and that's one of the very sort of significant sort of political handling issues that would arise. There's a logic behind the fact that if you're a private patient, you've elected as well not to use the NHS free at the point of delivery, therefore your damage should be considered separately, but it really doesn't sound very attractive.
No. Just on tariffs, one thing I did pick up from the report, which I thought was interesting, is that in Japan, they have a birth injury scheme, which does have tariffs. And I wonder if I threw it to the audience, whether they'd be able to guess what that tariff was. I have no technical way of doing it, but I can tell you that the fixed rate for birth injury cases in Japan is £195,000 lump sum, together with £8,000 per annum for 20 years. And that's it. So I put that out there as a matter of interest because I think it is quite interesting, because it's really quite a lot lower than I thought it might be if we set tariffs here.
And they have caps in various states in America, so you can't get more than, because of the fact that the medical profession was not able to insure, particularly obstetricians, able to insure themselves at all because of the amount of claims, the size of claims and jury awards.
Yes.
That isn't quite the case here, but I mean, if you think about the 300 million that we're sending to Ukraine compared with the cost of clinical negligence, that seems to a very minor contribution.
The next question we have submitted, the potential impact on the need for and careers of clinical negligence lawyers, brackets associates and partners in particular. Well, I mean, should these proposals ever be implemented, I think the impact would be very severe. There's a passage in the report where the committee notes, I think with a certain degree of relish, that the amount spent on lawyers within the schemes set up in Japan and Sweden is, I quote, minimal. And I think that's really what the committee is aiming at, really booting lawyers out of the process pretty much completely. So the impact, should these proposals ever go ahead, would, I think, be great. But Ed, you're not so sure that there's the political will to do this.
I'm not sure. I mean, beating up lawyers is always popular, of course, in any context. Yeah. And I can see that whichever party's in power, that could go down well. So you've got, on the other hand, you're going to have to fight against the fact that the plight of an injured claimant is politically one you don't want to mess with, because people have had misfortune to receive substandard treatment. And it will be said, I think, with some justification, that this is complex stuff. You need experienced lawyers to do it. So cutting them out of the picture is going to be difficult. I think, there's an argument for fixed recoverable costs or whatever, but I think that just beating up lawyers, look what happened in Lasso. That had a very, very rocky run through Parliament, although eventually did get in with a government, with a coalition government with a huge majority. But I'm not sure that it's going to find it at all easy to get through at the moment with a government which is not exactly confident. So I think that however much the desire to beat up lawyers may exist in all parts of the House of Commons and certainly in the House of Lords, that it's really going to happen.
I've got two more questions. One is, what political appetite is there to do this? And what about constitutional issues concerning government limiting its own claims exposure? I think, Ed, you've helpfully covered the political appetite. Constitutional issues, re government limiting its own claims exposure.
Well, I think the answer to that constitutionally is that Parliament can make any law it wishes, and that's the difference between the executive, i.e. government, and the legislative body, Parliament. The government promotes legislation, but ultimately it is Parliament that passes it. So although there may be a little uncomfortable constitutional aspect of the so-called elected dictatorship, which Parliament sometimes represents, essentially it's perfectly in order for a government to promote legislation which may result in a reduced exposure to claims.
And the final question, will the reforms deliver a better system of compensation? That's from Afzal, who you've already mentioned, who I think was participating in the chat earlier. I think it's difficult to say. It might be better from the point of view, ultimately, if the committee is right for the public purse, but I'm not sure that it would necessarily be better for claimants, although the committee would think it will ultimately be better for claimants because they'll get results quicker and more cheaply with less stress. So I think that's, I don't think one can answer that question sort of yes or no, really.
No, I'm not really convinced by this delay, this idea that everyone says there are delays, but of course the figures, as I understand it, and you've read it more closely than I have it, is on the assumption that you sue right from the moment the accident takes place. Well, we know that isn't always the case. There's often quite a long period of time, particularly in complicated cases when people go to lawyers, they think they might go to lawyers, they then decide whether or not they've got a case or whatever. Several years may elapse, particularly with children who have got limitation problems, before the case even starts. And I think it's actually a little unfair to suggest nowadays that these things are dragged out unnecessarily. But it's a sort of easy charge to level. And there are, of course, egregious examples of when cases have taken a very long time. But what is this administrative body going to, how is it going to manage? It's going to be overwhelmed with huge amounts of work. I can see the terrible possibility that the delays are going to be even more intense for the administrative body, which is going to be a necessary kind of exhaustion of remedies type position. And that's not going to solve that problem.
I completely agree with that, because I mean the administrative body, if awarding damages on the tort basis, would still have to grapple with complicated issues of causation and of course with quantum. So yeah, and the crystallization of a quantum claim sometimes is just impossible to do at the age of 2, 3, 4 or 5, and sometimes you have to wait until adolescence even actually to have a proper idea of what a claim is going to be worth. Although I suppose they might say that that's the problem with the once and for all settlement, whereas you could just review everything on a year-by-year basis. But that just seems to me to be a recipe for increasing cost and delay, because if every year you then have to employ a raft of experts to say how someone's developed and whether they now need a particular wheelchair or a particular form of psychotherapy, I just don't think it's really properly thought through.
There's also a terrible tension between the general principle that there should be an end to litigation. I know that periodical payments represent an exception to that anyway, but as you say, if it's going to be a continual going backwards and forwards to administrative body, I just wonder how desirable that is. I mean, I'm interested you mentioned the point about New Zealand and the causation issues. I mean, the idea that an administrative body is going to find this any easier than a judge to decide which cases merit compensation. I mean, all the same questions arise, and they are very difficult, and you need a lot of experts, and there may be more than one point of view. And you're depriving somebody of the right at least to have their case tested.
Well, that's all the questions, and we haven't got anything in the Q&A box. I hope that's not my fault for not mentioning it at the start. And we've dealt with the questions that we were asked beforehand. So, Ed, I'm going to thank you very much indeed. That's been really incredibly helpful, and to have your insight into how this report might be regarded and might be dealt with from the political aspect has really been helpful. I think, in conclusion, I think we would say there's nothing new here. We understand the impetus. It's mainly cost-driven, but ultimately, practically, we're not sure that there's enough in it for us to expect that these changes will be implemented anytime soon.
I agree.
And with that, thank you. And with that, I think I'm going to wind it up. So have a nice afternoon, everybody, and thank you for attending.